Walt, if you believe what's read in the papers today, Companies Act's unlikely to take effect tomorrow because lots of the documents haven't been signed yet.
That's absolutely right. We had a breakfast with DTI this morning. They intimated that they themselves could not make the announcement. There will be an announcement today. The minister has to make that. And they were quite categorical, really. Documentation hasn't been signed. The president has to sign 2 documents, the minister 1 document. That hasn't happened. I believe, and this is at this moment only speculation, that we are looking at the 1st of May as now being the official date, but that still has to be proclaimed by the president.
Madelein, have you heard anything? What's your expectation? Would we have this only by the 1st of May?
All indications point to that, yes. It seems as though 1st of May would be the date. Of course, we'll have to wait and see, and tomorrow morning when we wake up, we may have a different view, but it seems, I would say, 90% yes, it will only be the 1st of May. Are
companies ready for this new act, in your view, Madelein?
No, I don't think that they are. I'm not too sure that they will actually be ready on the 1st of May either. It is a huge process. It is an entire new act, new requirements, new provisions. I don't believe that they are and that they will on 1 May. But of course, and I think that's been the minister's approach, we can't wait for parties to be ready for the new act, then we will wait forever. Unfortunately, human nature is, of course, that we leave things until number 99. And if this is postponed, let's say another 6 months, we will be where we are now in 6 months' time.
Do you agree with that, Ewald? Because I see you laughing now.
I have to agree with that. You know, the process up to now has been problematic. We don't have the regulations, which are pivotal. They're 145 pages, which is almost as long as the Act itself. So there is no way people can be ready. But I have to agree with Madelein's view. South Africans particularly seem to be bent on preparing for things at the 11th hour. I would advise everybody very strongly, once the Act is published in a consolidated form, DTI has promised to do that, and the regulations are published, to study them and to get ready. There's a lot you can do, particularly now that the process is almost finalized. Get ready, because even a month is not enough. I really feel strongly about that. I think it should be longer, but people must do what they can as soon as possible, not wait until the last moment.
Because companies have been working according to the draft regulations, haven't they, Madelein? What are some of the hurdles or obstacles they might have met in trying to prepare for the new Act?
Well, first of all, the timing issue, and in that they never knew, we didn't know when this Act would come into effect. One of the benefits, of course, with us all thinking it would be tomorrow, is that parties became much more involved. They started to get their house in order, etc. They may have run out of time, and this month may well buy them that time. Of course, one of the difficulties that we now have is that some transactions have been structured on the basis that this Act will be effective tomorrow. And some requirements under the old Act have not been incorporated into a transaction under the circumstances. Now, if that transaction is implemented within the next month before the Act comes into effect, we do have serious problems there.
Do companies, though, have a leg to stand on since the Act was supposed to come into effect tomorrow? No, because it's always been, it has to be promulgated. You cannot rely on rumours in the market, etc. So no, they do not have any leg to stand on. No. Looking at the legislation, and it sounds like it is a big change from the old Act. 145 pages. You talked about regulations pivotal. Is it a world-class piece of legislation, though?
I think if one has to analyse that, I believe it is. I think it has moved South Africa from a fairly archaic, and it's not terribly, but a reasonably archaic Companies Act into a more modern positioning. I think that that is absolutely true. And something like the business rescue provisions are pivotal. How well it will work in practice is the question. Obviously, we all have to ask and see how people will accept this. But I think conceptually, we do have a good Act.
Mm-hmm. What are your clients telling you? Do they welcome this new legislation? Do you have any issues with the new legislation?
Look, I think once again human nature is to resist change, and people feel that they are familiar with the old Act and they want to continue with the old Act. There are positives in the Act. I think that there are a number of additional minority protections in the new Act, which is great. The Act, of course, also one of the stated intentions are that it will make, and it should make, doing business easier, and I think to a large extent that is achieved. Unfortunately, in some instances, it does not benefit minority shareholders, but definitely from that perspective. And of course, there are concerns. For instance, group loans, and that you now need a special resolution, and solvency and liquidity, and fairness and reasonableness in the case of making a group loan from one subsidiary to another. That was never the case, and it will impact severely, especially on our large corporates.
So is it creating more red tape in some instances in that case?
Yes, absolutely. Needed a board resolution in the past, now 3 additional requirements. So for the most part, matters which used to go to shareholders can now simply go to the board. Obviously, less red tape, but then you can amend that to protect your minority shareholder. If you don't amend, the minority shareholder is exposed. But yes, less red tape from that perspective, more red tape in certain areas.
But if you're bypassing shareholders and going to the board for some resolutions, is this good for corporate governance and transparency, Ewald?
I think it is, because you need to facilitate the business operations, and I must concur with Madelein there are certain provisions that just really don't make sense to us at this point. But in terms of the governance, it is accompanied by an increased focus and increased responsibility on directors. So the governance, I think, is maintained because of the onus being supported by directors' liability, and then also a general provision of liability in Section 218. So I think the governance issues are not of concern to me.
Should directors be worried, though?
Directors need to be cautious, very much so. There are much greater expectations of them. There is still the protection that we are reasonably accustomed to, which is enshrined in the Act. But there is still an open debate as to whether the general provision for liability can extend to directors and whether the protection afforded them will stand up against that. I think it will. It's logical that it should. But directors should be very cautious, and I always point out to people one particular provision, Section 4 of the new Companies Act, says that when you make a distribution, directors will certify that the company is solvent and liquid at that point and for the next 12 months. That is onerous. And I think directors need to document, they need to be very careful as to how they follow process and how they document that process.
Madelein, would you expect any changes, any dramatic changes in the final regulations once they are put through?
We don't expect dramatic changes, no. The regulations published in 2009, those now published in 2002, they were vastly different. We didn't even get a markup of the 2009 draft regulations because they were so very different. Comments have been made on these draft regulations. There has been no communication back, but of course, since we expected this to come into effect on 1 April, we also expected that they would come into effect exactly as they were published in 2010 with small amendments.
How easy do you think it's going to be to implement all these new changes for the average business, Ewald?
I think it's going to be quite tricky, and my major concern lies really with smaller businesses who don't have the wherewithal, first of all, and don't have the resources to actually prepare themselves adequately. And again, the trend for us to leave everything to the last moment. People will need to get accustomed to new forms, new processes. The new annual return is very different to the old one. The forms themselves have changed, the numbers have changed. So people have to get past what they're accustomed to and focus on the new. There are certain processes. Madelein is an expert on this one, particularly the Memorandum of Incorporation. People need to focus on that, to really look at what they require, not just opt for the short form, which will be available, but they need to think about what sort of protection they need. Shareholders' agreements effectively fall away, and you need to take those provisions and put them into an MOI, unless they are contrary to the Act, of course. So people need to go through a process. It's going to be difficult for people to cope with the changes. There are many changes, and I think they have to get over the conceptual hurdle first.
Are you anticipating a big pickup in business over the next couple of months in that case, Madelein?
Yes, I always joke and I say when M&A goes down, the government gives us a new act. So
we have to leave it there.